So I'd like to introduce our speaker tonight. We have with us Professor Chris Kendall from the University of Puget Sound. And as a brief introduction to Chris, he grew up in a small town in Ohio and went to college there in Miami, the Ohio Miami, and studied history and earned a law degree from Berkeley. He practiced international law at a firm in New York City and then transitioned to academia to work with students interested in social justice law. So eventually he became frustrated with legal theories seemingly lack of engagement with political constraints. So he went back to school, earned his PhD in politics from Princeton, and has been teaching at Puget Sound, at the University of Puget Sound since 2015. So I will turn the screen and the program over to our speaker tonight. He is going to talk to us about the International Criminal Court, Human Rights Beacon, or Threat to Sovereignty.
Awesome. Thank you so much. I'll go ahead and share my screen then too, in the hopes that this actually works. So gonna ask Amy if you can still see that.
That's perfect. Looks good.
Awesome. Thank you so much. And thanks everyone for having me and for taking time to sit and chat a bit tonight. I'm going to be talking about the International Criminal Court, as Amy pointed out, and I want to frame this primarily as a discussion between some of the ways in which people have looked towards the ICC as sort of this hopeful institution that can help humanity overcome crimes of war and aggression, et cetera, but also at the same time the opposite side of the argument, which is that it's a threat to state sovereignty. So I'll talk us through a bit of the historical context, and then I'll spend a little bit of time talking about the evolution of the US stance towards the court from the Clinton era to today. I want to then briefly discuss some of the ways in which this court has been important for other states. Since the US is not a member of the ICC, a lot of other states have a lot more of a role and a lot more invested in this court. So I want to talk about some of their concerns. And then I'm going to shift to the court today and really focus on some of the current controversies as to how the court functions, some of its limitations, and maybe some of the ways that the US could engage with the court in the future. But starting with just the historical context, some of this is probably review for a lot of people that are into history, but the ICC really traces its origins back to the Nuremberg trials, right? And so the post-World War II origins of this court really come out of this idea that international humanitarian law is a universal. It's something that can be applied to all people everywhere, and that everyone agrees certain things just cannot happen, that there are such gross violations of human rights. The Nuremberg model is also an attempt to avoid some of the mistakes of the post-World War I settlement that saw collective guilt imposed on Germany as a nation. And so instead of following that same model, the Nuremberg model was to treat law as a pathway to justice, not retribution, and to, instead of holding an entire nation accountable, only hold individuals accountable. And by having trials to expose crimes and allow the court to then play some sort of educational role to society, and in some ways, not just justice, but the beginning of a healing process and sort of a recuperation of society. There are obviously lots of problems with this model. Just to name a few, the fact that Nuremberg was seen in a lot of ways as, ex post facto lawmaking, because things maybe weren't technically illegal under treaty law or international law, that the application of justice was selective, right, in terms of the nations that were on trial, but also in terms of the individuals within states who were chosen to be put on trial. And then just the general framing, of course, of this as just more victors' justice. And yet, despite these problems, this court, more so than the Tokyo court, the Nuremberg model is seen as sort of the basis of what becomes the ICC, or some of its intellectual origins. during the Cold War, like no real progress is made, which is sort of interesting, given that you go from the 40s to the 90s, a half a century with no real progress. And a lot of this is because during the Cold War, that consensus, that universality about the World War II era conduct of Germany and is just lost, right? And there's a move away from universality towards liberalism as a regional affair. Liberalism really retreats from being a universal goal to really being a question of the West, right? The US and its allies. And frankly, a lot of these states just aren't interested in having any sort of universal court at this point. Right? European concerns are really focused around imperialism, decolonization. It's not clear that it would really behoove Europeans to have people looking into human rights violations around the globe. The politics of the United Nations are difficult. You have developing states, communist states, things are just very politicized. And so there's no sense of universal anything really. And then in addition, as some of the newly decolonized states gain independence in the 50s in particular, a lot of those elites are not in any rush to give up sovereignty and provide it back to another international institution, even in the form of a rights protecting court. So we just sort of see a hiatus for a good half century. And that all changes as we know at the end of the Cold War, right? The post-Cold War era is transformational. Right, there's this moment, right? The end of history, the triumph of the Western liberal model, and it appears for a time that there's a return of consensus in terms of how states and how the international system should be organized. This includes reinvigorating the United Nations. More work starts happening through the Security Council, including peacekeeping. But still, there aren't really universal courts, right? The only universal courts are the old ICJ, the International Court of Justice, that's created as part of the UN system in the 40s, and then the GATT, like trade dispute mechanism, and those are pretty much it. Instead, what we see are the beginnings of proliferation of ad hoc tribunals, right? So the UN has authorized actions, peacekeeping actions in places like Yugoslavia and Rwanda. They're not going so well, and like no one really wants to get involved though, but the UN feels like it must be seen as doing something in response to these atrocities that the West pretty much failed to prevent. And so what the UN does is it creates, under its Chapter 7 authority in the UN treaty, it creates these ad hoc tribunals, the Criminal Tribunal for Yugoslavia and another one for Rwanda. And it's really, in a sense, a way of offloading some of these political problems. And so in a sense, it sort of builds on that Nuremberg tradition. Again, these are ad hoc, just like the Nuremberg trials were, just like the Tokyo court was. And they're selective. They only apply to certain people. One difference that might be seen here is that these aren't victors' tribunals, right? They're sort of third parties creating them. And they use existing law at this point, right? The laws that are being violated, the international law, the humanitarian law, the human rights law, are well established at this point. So there's no question about ex post facto anything. There are problems, however, with these courts, right? And it really comes down to their limited nature, limited geographically and temporally, right? There are human rights crises all around the world. Why Yugoslavia and Rwanda, but not elsewhere? And why courts that are temporally limited, right? If part of what we think criminal law can do is deter future criminal behavior, that only works if there's going to be a court in the future where someone could be tried. And if someone commits a crime in Nicaragua, they're obviously not going to be tried in the ICTY that's only for Yugoslavia. So that's a problem. And the solution is to go back to this idea of a permanent universal court, a court that will pre-exist the atrocities, hopefully prevent some sort of deterrence effect, but also just be ready and freestanding and ready to go when it is needed. So the development of the court occurs within the General Assembly primarily. Caucus sort of develops in favor of this court. That caucus finds itself somewhat in opposition to a lot of the Security Council veto holders because of their different sort of positions in the UN system. Obviously, the Security Council veto holders are very concerned with maintaining control over everything, in the General Assembly has a lot more states with a lot less power, and they have a different agenda. During the UN process, there are discussions on which crimes, how to define those crimes, who will control prosecution. And this question of prosecution really becomes one of the biggest sticking points, in particular for the US, because the US wants to be able to have sort of a veto over prosecutions for obvious reasons. Like, the US is sort of unique in terms of being a country or a state that has global security concerns and a global security footprint. And so it's worried about being put in that position and then simultaneously having its troops held accountable outside of its own courts. So as these negotiations wind up and the treaty gets drafted, the court finally arrives in the early 2000s. So the Rome Statute, the treaty that governs and creates the ICC, is open for signature in 1998, and states have until December 31st, 2000 to sign up for it as initial ratifiers. And enough states sign and ratify that the court comes online in 2002, and it comes online without the US as a member. So through the negotiating process, the institutional structure of the court is determined. And just to sort of lay out some of the ways in which this court is organized. One is in The Hague, right? So it's off in Europe, like a lot of courts. It operates on a principle of limited jurisdiction, and its jurisdiction is limited in a lot of ways. One of the most important ways that it's limited and that states really pushed for was this idea of complementarity, right? So the ICC is a court of last resort. It's not the place people go to first. The ICC only acts when no one else can or will, right? So it only acts when a state cannot or will not prosecute crimes. It also has a limited jurisdiction in terms of the substance that it can look into. And it's basically limited to 4 crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. There's a little asterisk next to crime of aggression because they couldn't actually agree on the definition of that by 2000. So they had to come back and amend the treaty about a decade later, but now it's in there too. It only applies to crimes that occur after the statute comes into force, right? So they can't go back and look at things in the early 90s, right? And it only applies through a member state. So it applies on the territory of a member state, or if a member state's nationals commit one of the crimes in the statute. So that's another way in which this is limited in terms of how the court can act. So that's the general jurisdiction, but how is that exercised, right? And this was the real sticking point for the American, the US administration. There are 3 ways, right? One of the states that's a party to this treaty can actually refer a situation and say, this situation is occurring, we want you to investigate it, and then the prosecutor will investigate it. A situation can be referred by the UN Security Council. Right? This is the US's preferred route, what it wanted, because then it would always be able to exercise that veto if it wanted to. So the UN Security Council, acting under Chapter 7 of its powers, can refer a situation to the ICC, and the ICC will investigate it and prosecute it if appropriate. And then the third route, the one that really, really worried the US, is the idea that the prosecutor at the ICC, often The Hague, can initiate their own examinations of issues around the world. This is called the prosecutor acting proprio motu, right, with their own initiative. So one of the one of the ways in which this is sort of a little bit of a protective layer is put in there is, unlike the other two approaches, if the prosecutor wants to investigate, they have to get approval from the pre-trial chamber of 3 judges, basically, to tell them that, like, yes, okay, you can actually begin the actual investigation. This is reasonable. You have some reasonable basis for believing this. So the US role. So the US role sort of fluctuates back and forth throughout the 90s and up to today, right? So Clinton's approach was pretty much yes, but. So they were very interested and supportive. They actually had the US had a large role in the sort of definitional aspects, thinking through how the court would work. But it really came down to this concern with the ICC having the prosecutor's power of initiative, right? To act without the Security Council telling them to act. And then also the second primary concern was the ICC having jurisdiction over non-state parties' citizens, right? And so what that means is if there are war crimes allegations in, say, Congo, if Congo is a member of the ICC, then anyone who commits or is accused of committing war crimes in the Congo could be tried by the ICC, even US citizens, right? Even though the US didn't sign the treaty, the fact that they were in the Congo where the situation occurred opens them up to being prosecuted as well. And that was a major sticking point for the US, given its massive footprint around the globe. So there's in Clinton style, there's a bit of hemming and hawing, but on the last day of 2000, December 31st, 2000, the last day that the treaty was still open for ratification, for signing, Clinton signs. This is not greeted fondly by Republicans in Congress. They consider this a lame duck action, to some sort of attempt to bind the US on as he's walking out the door. Clinton saw it as a way of keeping open the possibility of future ratification, and even said basically he didn't anticipate ratification anytime soon. But nevertheless, with the changeover to Bush 2, the US walks that back. And so in 2002, Bush basically indicates to the UN that the US is officially unsigning the Rome Statute. It's not clear if this has any real legal implications, but the idea was basically just to make clear to all the other signatories of this treaty that they should not be waiting for the US, right? And so from this period over the next probably about 5 or 6 years, the US role shifts to pretty clear and concerted efforts of opposing this court, right? And one of the most concrete forms this takes is a law passed in 2002 called the American Service Members Protection Act. This is a bipartisan initiative, right? So then Senator Clinton voted in favor of this, Kerry voted in favor of this. Biden did not. He thought it was unnecessary, given like basically US power in the world. It wasn't really necessary. But what it does, it basically prohibited the extradition of US citizens or residents to this court. And it went farther in authorizing, quote, all means necessary to secure the release of US citizens or residents if some other state had them and was transferring them to the court. So this is sort of jokingly referred to as like the Invade the Hague Act, like the US is going to invade Europe under this act. But perhaps more meaningfully in terms of actual effects is that it prohibited a lot of various means that the US otherwise could have supported the International Criminal Court. So for example, financial support to the ICC, law enforcement cooperation, intelligence sharing, the ability of US courts and state and local government entities from responding to any requests for information and cooperation from the ICC. So really trying to put some roadblocks into any sort of cooperation and make it very clear that the US was not happy about this court. There was, however, a bit of a carve out, right? So Senator Dodd, his father was a prosecutor at Nuremberg, so very dedicated to the idea of like international humanitarian law and international human rights law, had an amendment that carved out the ability of the administration to assist the ICC against foreign nationals accused of genocide, war crime, or crimes against humanity. It wasn't targeted specifically at the ICC, but it was targeted basically at courts and allowing the administration to help in that. It did not apply to assisting with anything that might implicate US officials, but it allowed a lot of future actions that the US ends up taking that actually helped the ICC in some of its cases. So one of the other effective, symbolic, you choose, means of resisting the ICC took the form of what were called Article 98 agreements. So the Rome Statute has, hundreds of articles saying what states are required to do, what they don't have to do. In general, they're obligated to cooperate with the ICC. Once a state, let's say France, signs up as a member of the ICC, one of the requirements of their treaty obligation is to actually cooperate, right, and turn people over and provide information if available. So Article 98 of the Rome Statute basically says, yeah, but if you have some contrary international law obligation, then you don't have to turn over individuals, right? So France, you're required to turn over individuals to the ICC unless it would be contrary to some other international law obligation you have. So the Bush administration, they have some good lawyers working for them. They're just like, aha, well, this is perfect. So what we're going to do is we're going to help all of these countries around the world make sure they have some obligations under international law. And so basically what they do is they pursue a series of bilateral immunity agreements under Article 98. Basically, they say, for example, with Nigeria, hey, Nigeria, you've signed up for this new court. We would like to sign a bilateral agreement with you in which we agree that neither of us will turn over any of the other state citizens to the ICC. So the little map on your screen, the very light blue are sort of irrelevant for this conversation, but the medium blue are member states of the ICC that have signed these agreements with the US, and the dark blue are non-member states that have signed the agreements. So there are quite a few. So by 2006, about 100 states have signed up to these agreements, saying that they will not cooperate by sending US citizens to the ICC. So it's a pretty successful initiative. It is encouraged in its success by the APSA, the statute we were just talking about, which requires a BIA agreement for any state to consider receiving military assistance. So that's a real incentive for states to sign up to these. And it helps explain why a lot of poor states sign up for them, but not maybe some of the richer European states. 2006, this part of the ASPA is actually repealed for a few reasons. One, military leaders in the US just don't really like it. They argue that it could actually prevent engagement with military and civilian leadership in various parts of the globe, in particular Latin America. And they're concerned that in various parts of the world, if the US cuts off military assistance, then some other country like China could step in to the US's role in providing military assistance. And then in general, the EU and a lot of the US's NATO allies are pretty strongly opposed. So by 2005, 2006, this is sort of soured and Congress actually repeals it. And then Obama comes along and we start the policy ping pong that we're going to see in all sorts of American policy over the next 12 years, right? So under Obama, there's a move towards some positive engagement, right? Some of this starts under Bush, right? In March of 2005, the US agrees, it refrains from using its veto at the UN Security Council, and the Security Council passes a resolution telling the court to investigate the genocide in Darfur, for example. And then the US will even later block efforts by China to defer that investigation So there's actually some progress in how the US is dealing with the ICC even under Bush. Appropriation bills, however, continue to restrict direct funding to the ICC, but they are loosened a little bit to allow some technical training, assistance with victim and witness protections. The Republican members of Congress agreed to allow taxpayer dollars to help pay for detention and transfer of, for example, Joseph Kony, who is part of the Lord's Resistance Army, and having him sent to the ICC for prosecution. And there's also an expansion of the War Crimes Reward Program, right? This is a program that basically pays money to people that help basically get the worst criminals who are involved in things like war crimes, and that's extended to the ICC as well. So this is considered positive engagement, or as Obama calls it, a sort of case-by-case analysis of how the US is going to act with regard to the ICC. When Trump comes into office, there's a lot of rhetorical opposition very quickly in general to international organizations. And in particular with the ICC, the Trump administration considers this, quote, an unusual and extraordinary threat to national security. The really intense opposition comes a little bit later, though, in 2019 and 2020, when the Office of the Prosecutor of the ICC seems to be going down the exact road that the US, all the way back in the late 90s, was most concerned about. And the Office of the Prosecutor starts investigating highly political situations, namely Afghanistan and Palestine. So the Trump administration is extremely opposed to this, as are lots of members of the US establishment for various reasons. And by 2019, they actually start engaging in some sort of targeted actions. So they revoke the prosecutor's entry visa to the US. There's an executive order imposing sanctions on the ICC prosecutor, Fatou Bensouda, and another one of the senior officials at the ICC, Pakiso Motochoko. But again, it's mostly oppositional, but there are still some bits that continue, including like the War Crimes Reward Program that continues and is even expanded to include potential Syria defendants. So there's not a complete abandonment of some of what the US is doing. And then we flip back when Biden comes into office this year. There's a return sort of towards the Obama style approach of tentative support. And there are various reasons for this. Part of it's because Biden has sort of always been more realist about this in terms of recognizing that international institutions might be helpful, but not particularly concerned about them being too powerful given the US's relative heft in the world. So by early April, his administration rescinds those ICC sanctions. But at the same time, they've been very vocal in their opposition of the Afghanistan and Palestine investigations. His agenda, his approach to the ICC is still evolving. It looks like it might be heading in the direction of the Obama administration, sort of a case-by-case analysis of how much to be involved. And it's unclear what role the ICC will play, if any, in Biden's broader democracy agenda, trying to reinvigorate international institutions and outreach to traditional US allies. Okay, so before we get to some of the controversies, I just want to briefly touch on why some of these other countries would be interested in joining, given what we see as quote unquote sovereignty costs, right? That's what political scientists call this. Like when you join an international organization, you give up some sovereignty. The US has been pretty clear that it's not interested in that trade-off. And yet a lot of other states have. And so why is that? Around the globe, 123 states, and I'm using states generally, right? The way we use it in international relations to talk about a country. 123 states have joined the ICC. And ratified the ICC, 43 European states, 33 in Africa, 28 in Latin America, and 19 in the Asia Pacific. There's some obvious outliers, right? You look at the map, China and India, right, are both white, they're non-signatories. So there you got like, about half of humanity has said, no, thank you. And then there are a lot of countries, sort of like the US, that have signed and then just never got around to ratifying. So they're not bound by it. So like Russia, for example, Iran, that's pretty common as well. And then there are a few countries that have sort of changed their mind, and we'll get to them in a minute. But so why are these countries interested in joining? In particular, why these high levels of ratification in Europe, Latin America, and Africa? Well, Europe and Latin America are a little different. I mean, every region is a little different. Europe and Latin America, though, have a little more of a history of engaging international law in a positive sense. So in Europe, international law has been embedded domestically for a long time. Like their entire post-World War II process of internationalization through the European community, through European human rights treaties, has been about creating international law, creating international courts, and binding themselves in domestic law, right? Like the European Court of Justice, European Court of Human Rights can override things that national governments do, and Europeans have learned to live with that. They also have learned to live with the idea that non-state actors can initiate review. So they're not quite as concerned about the idea of, say, a prosecutor having some freedom of movement, because that's what they're used to. The European Commission can do that in the European Union. Individual members of European states, individual citizens, can bring claims in these various international courts. So they're used to these non-state actors. In Latin America, there's a similar history of engagement with international law, or at least long-standing, not similar, I guess, but long-standing in terms of timeline. It's important to remember, unlike African states or states in Southern Asia or South Asia, East Asia, like all of the Latin American states were already independent states when the UN was created, right? So they were there at the founding. They helped draft things like the International Convention on Civil and Political Rights. So this is not new to them. In addition, in the 80s and 90s, the spread of the Washington Consensus, this idea coming out of Washington about the benefits of neoliberal policies, the benefits of rule of law, binding economic legal regimes, that spread throughout Latin America as an idea. But in addition, the 80s and 90s is a period of democratization in Latin America. And so there's a willingness to embrace the rule of law. See this somewhat in Europe as well, right? So like by the time the International Criminal Court is coming up for ratification, you have all those Central and Eastern European states like Poland, Czech Republic, Slovakia, and then Latin America, Chile, Argentina, Brazil, countries that have democratized, and now they're trying to lock in that democracy, right? So one of the things we find when we compare these states around the world, political scientists find that often the strongest supporters of international courts have been those states with the least consolidated democratic tradition, right? Because they don't take it for granted. So like US isn't that concerned. It's not worried about like, oh, well, we have to join this court because otherwise there's going to be a genocide in the US, right? But some other states are actually concerned about that. So they want to lock that democracy in and have some external actor actually looking at what their country is doing, what their government is doing, and making sure that they can see from miles away when the bad action is coming down the pike. Africa, whereas Latin America and Europe are primarily sincere ratifiers, we expect them to be ratifying the treaty because they want to follow through on it. In Africa, there's some sincerity, some insincerity, right? Part of it is just isomorphism. So one of the things we see in African international relations is that international relations in Africa often follows institutional trends in other areas. So the African Union, for example, in the 90s, transforms from the Organization of African Unity to the African Union, which looks a lot like the European Union in terms of the actual institutional structures. The African Commission on Human Rights looks a lot like the Inter-American Commission or the European Commission on Human Rights that came before it. So that's what we call isomorphism. They're sort of like mimicking the structures because they think there must be something good about it. Works for these other places, maybe it'll work here. There are donor incentives, right? It's not so much the Washington Consensus like we see in Latin America, but rather the UN Millennium Development Goals, right? Start having very clear markers as to what what is going to entitle you to ongoing funding, right? Individual private donors start tying things to reforms. And so ratifying something like the ICC statute is a way of indicating to donors that, like, no, we are binding ourselves to these important international institutions that protect the rule of law. We're doing the right thing. We're going in the right direction. There are also transnational elite linkages. A lot of attorneys, judges, et cetera, in Africa are trained in Europe. And so they just, or the US. And so they come back and have they're true promoters of this. They actually believe it's the right thing. And then also it's a way of demonstrating commitment in terms of similar self-binding logic. But in Africa, we can see that it actually might even go a little farther, because self-binding seems to work even in states that are still having some trouble with domestic insurgencies, perhaps, or civil war, because it allows the government to demonstrate its credibility domestically. So you can imagine, like, an insurgent movement has some weapons and doesn't want to give them up, but then the government ratifies this treaty, and then the government can say, look, if we go back on our word and slaughter everyone, we're going to be held to account. So there's, again, that self-binding lock-in. So on the one hand, maybe some empty promises, doing it for other reasons, wanting some donor money, et cetera. But it all seems like domestic politics is, for a lot of these states, actually pushing them towards some sincere ratification. Okay, the court today. So the court has been operating now for 20 years. There are some success stories, some not so successful stories, right? Dominic Owen, right? Yeah, he's now the first Lord's Resistance Army suspect to be transferred to the ICC and actually prosecuted. He was convicted this past February for 61 counts of war crimes and crimes against humanity, right, in Uganda and the surrounding states. So he's serving his term now. The Congolese military leader Bosco Ntaganda for crimes against humanity in the Democratic Republic of Congo. At the same time, there are quite a few outstanding criminals, alleged criminals out there that haven't been caught, right? Like there are still 12 that are just roaming free, like Omar al-Bashir, right? Or well, not roaming free, but not the ICC. And overall, there hasn't been a huge institutional output from this court, right? It's done a lot of work, it's spent a lot of money, but we're talking a couple handfuls of prosecutions over 20 years. So that's a point of concern for those who think this court needs to be reformed, right? But there are success stories, but I want to focus on some of the bigger controversies that are really facing the court right now. And I break those into a couple of concerns. One focuses on those sovereignty concerns, the costs of giving up your sovereignty, and the other to focus on those politicized investigations of Afghanistan and Palestine, right? So sovereignty concerns. The first of these is this charge that the African court is in essence a form of neo-colonialism. And this charge arises in the 20 teens, because for the first dozen years that this court's in operation, all of its cases are in Africa. So African heads of state, some activists are saying, like, well, what's going on here? Is this just neo-colonialism? So this list here on your screen right now, these are the 16 current controversies being investigated, and 10 of them are still in Africa. So it's only 2/3 now, still a lot. And so that's a cause for concern. And so this claim of ICC neo-colonialist behavior sort of came to a head in 2016 when South Africa, followed by Burundi, followed by Gambia in quick succession, all provide notice to the ICC that they're done, they're leaving the court. And so there's a bit of concern for a while that there's going to be some sort of African exodus. And since all the work that the court has done at this point is in Africa, that poses a problem for the court. It's quickly, however, countered by 16 other African states who pen a letter signing on and showing their support for the ICC, talking about the important role it plays. And this includes a lot of the continent's democracies like Botswana, Ghana, et cetera. So there's some pushback. And that pushback has an effect, right? Within a year, Gambia and South Africa have withdrawn their notice that they're going to withdraw. So they're still members of the court. Burundi follows through on it. And so that's one of two countries around the world that have withdrawn from the court, the other being the Philippines out in the Pacific. But it brought to a head this question of like, who is this court for and what is it doing? And so the claim was, well, this is primarily a white court run by Europeans and prosecuting Africans. And the prosecutor at the time actually had a really good response to that. She is from she's from Gambia. And she basically said, yeah, we're prosecuting Africans, but all the victims are also African. So this is a court for Africans. And so that really seems to have carried the day, that approach. One thing that I think is sort of lurking behind the scenes, and I listed here as like the potential for a shadow institutional exit. This is one of the things I'm researching now. African international institutions include an African Court of Human and People's Rights. And so this is a court that's in force. It's not particularly active, but there has been talk about transforming that court to include a criminal chamber, right? So that it would actually oversee on the African continent criminal prosecutions, and it would be more in line with some of the political preferences of African leaders, including sovereignty for immunity for heads of state. So there's this possibility that there's no institutional exit right now. There's no big exodus, but there is this sort of waiting room if this becomes an issue in the future. So these shadow challenges to the ICC are always out there, and they do seem to provoke a bit of a response from the ICC because there's been a transition away from Africa a bit in the ICC to other areas of the globe. Another area of controversy is just how much room is there for difference, right? Like, is the ICC just another one of these big international organizations that's trying to impose uniformity around the world, like the IMF, like the World Bank? So one area this plays out is in the issue of complementarity. And remember, that's that idea that the ICC won't act unless the domestic court is unwilling or unable to. So this was really imagined as a shield to protect domestic sovereignty. The problem is that unwilling, unable determination is made by the ICC. And so in some ways, it's almost become less of a shield and more of a sword, sort of a sword of Damocles that the ICC can sort of hang over a domestic system, saying like, look, you have to do it our way or it doesn't count, right? So the ICC, for example, has a real focus on a prosecutorial approach, right? They're really concerned with retributivism, or at least with not allowing any chance of impunity, right? So prosecutions are the way the ICC deals with issues. They're not looking at like, truth and reconciliation commissions. That's not their job. Their job is to prosecute. And so if you're not prosecuting, they think you're not complying with your obligations. So there's a concern that this complementarity is actually incentivizing standardization. So you have like NGOs, legal NGOs, basically pushing states like Uganda and Kenya to use model legislation based on best practices that comport with the ICC, right? So that's one. The second is this idea of interests of justice, right? So the Article 53 of the Rome Statute allows the prosecutor to not engage in a prosecution if it wouldn't be in the interests of justice. And this really hasn't been used as well as it could have. So the goal of the ICC is to overcome impunity, right? They want to be able to show that, look, if you engage in war crimes, if you create horrible conditions that amount to crimes against humanity, that you're going to be held to account. The problem is transitional justice doesn't always work that way. And by transitional justice, I mean the period of justice that occurs as a country is democratizing and dealing with past trauma. So think Argentina after the military junta collapses, and you still have these people living in your state. You got to do something with them. Same thing in South Africa, right? The transition from apartheid isn't like a simple affair. It's not like everyone just is prosecuted, right? You're still living with a huge part of the population, which you consider sort of guilty for apartheid, but you can't lock up everyone. So you have a truth and reconciliation process instead. That doesn't really work for, for the ICC. And so there have been claims that they should use this interest of justice and say, look, something like seeking the truth, something like reforming laws and institutions, in the interest of justice, we're going to let that be enough, because otherwise it would destabilize the society, right? Because you're going to have these people that are still there with guns who are going to fight back. There does seem to be movement in this direction. Just a couple months ago, the new prosecutor, Khan, actually announced the closing of an investigation in Colombia. Colombia has been under investigation by the ICC. And again, it's this idea that your transitional justice process isn't good enough. You're not punishing people enough. And the transitional justice in Colombia is all about a peace process with the FARC. And so basically, the ICC has said, okay, you know what? You're going for a different approach. You're going for truth seeking. You're going for reform. You're going to have some criminal prosecutions, not as many as we'd like, but it looks like you're dealing with the issue. So we're going to call off our investigation for now, right? The agreement that they made includes the possibility of the ICC coming back, but at least for now, they're willing to enable this process to continue. And the good ones, the politicized cases, right? These are the fun ones. So two of these, Afghanistan and Palestine. So like mentioned at the beginning, there can't be a prosecution in an investigation in a state unless that state is a member of the ICC or has been referred by the Security Council. In that case of Afghanistan, Afghanistan actually joins the ICC in 2003. By 2007, the prosecutor, that's her there, Bensouda, has completed her preliminary examination, and she requests authorization from the pretrial chamber, right? Now, she has to request authorization to seek further action, like an actual formal investigation and indictments, because this is a proprio motu case, right? She does this on her own based on information that has been presented to her by like human rights groups, etc. 2019, the pretrial chamber hearing that rejects it. And one of the reasons they reject it is because of the political context. It's like, this just isn't going to work. I mean, the US, no, it's not going to work. She appeals it, and the 2020 chamber actually allows it. The appeals chamber in 2020 allows this investigation to continue. So what this means is, as of 2020, the prosecutor now has the institutional backing to engage in investigations of rights violations in Afghanistan after 2003, when it joined the ICC. So that means looking at behavior of the Afghan military forces, the Afghan police, Taliban and other insurgents, US and allied forces, right? Because even though the US is not a member, it is operating in a member state of the ICC. The CIA, right? All those claims of torture, etc., those are now up for grabs as well. And not just in the territory of Afghanistan. One of the things that the appeals chamber allows is it says that basically she can also investigate in other areas or other states that have a nexus to the conflict in Afghanistan. So now we're opening up the possibility of the prosecutor considering crimes in places where, for example, the CIA maybe has some clandestine detention facilities, places like Poland, Romania, Lithuania, all three of which, for example, are ICC members and therefore are obligated to cooperate. So there's a problem for the US, right? In 2020, Afghan officials request that the investigation be paused, right? Note that request comes almost exactly a day after Pompeo visits Kabul, right? So there's clearly a little concern there on the US part. And so basically that is then paused, that investigation is paused, the prosecutor respects that. she leaves office in June, and the new prosecutor comes in. His name is Khan. He's right there on the left of your hand side of your screen. He actually, in 2021, indicates an intent to resume the investigation, and there's some clear reasons for this, right? Like he says, look, there's been a change. There's a material change in conditions from when this pause was requested. Namely, the people that requested it are no longer the government, and we have zero faith that the new government is actually going to try and be willing and able to conduct an investigation on their own territory. So the complementarity principle kicks in and the ICC is going to act. But Khan seems a little more politically aware or willing to work with the US, because he's when he announces this, he also announces that he's going to deprioritize the US. Right. So he's going to focus his energy where it can do the most good. And that focus is going to be on members of the new government and ISIS-K, right? ISIS-K being the Islamic State in Khorasan province. It's like an ISIL affiliate. So that's a change. And it suggests that perhaps, again, the ICC is reacting to some external political pressure. Maybe, we'll see. One where it's not clear, there's as much awareness, but we'll see, is with Palestine. So in 2015, Palestine accepts ICC jurisdiction, right? On January 1st, it asks the ICC as a non-member, under Article 12.3, it says, it's like, hey, please go investigate this situation in Israel, or in Palestine, in the occupied territories. And then a day later, it joins, deposits instrument of accession on January 2nd to become a state party. It says that what it wants to have investigated are violations of rights and war crimes violations that are since June 13, 2014. I'm sure it's just an absolute coincidence that is when Israel started its Operation Protective Edge, right? This is where Israel basically starts to really push back in 2014. And so basically, this is the situation that the Palestinian Authority basically gives to the ICC as this is what we want you to investigate. This is where what we allege are war crimes are happening. And basically in 2015, the prosecutor opens a preliminary investigation. And in 2018, by this point, Palestine is a member state, or acting as a member state of the ICC. And so it refers the same issue to the ICC again, now under a different article of the statute because it's a member. And Bensouda concludes that there is basis for an investigation. And this is what really kicks off the pushback from the Trump administration. In 2020, she asked for pretrial chamber clarification because she basically she wants to cross her T's and dot her I's. She's like, I don't know exactly what the territorial scope of this investigation is because there is no clear demarcation for these boundaries of this Palestinian state. In February of 2021, the ICC determines in one of its chambers, determines that the Palestinian territories are within the jurisdiction of the ICC. And basically that includes the boundaries of 1967, right? So the West Bank, Gaza, and East Jerusalem for purposes of jurisdiction of the Rome Statute. So on March 3rd, Bensouda announces she's going to investigate this. So the investigation commences. Immediately, Israel and the US voice their opposition. Netanyahu calls this just basically rank anti-Semitism. Blinken says, basically just in terms of legal principles, Palestinians don't qualify as a sovereign state. So it doesn't even make any sense for this to be happening at the ICC. But the current status is this is an open issue. It's an open investigation. And so it's going to be really interesting to see what happens with this one and whether or not there's any pullback from Khan, the way he's managed to dial down sort of the opposition with the US in the Afghanistan situation. All right, we're going on 8:30, so conclusions. So broad conclusion. The ICC is a political institution. right? And in some ways this seems obvious, right? But I say this because courts aren't always treated as political institutions, right? The post-Cold War attempt to create this institution was also simultaneously an attempt to transcend international politics with a legal institution. It's in that sense almost reminiscent of like the League of Nations, where it's just like politics aren't working, we're going to just create a legal institution and move beyond politics. And so I think one of the things that's really important is that we just need to recognize that this is a political institution, especially when the issues are so highly politicized. There's no way to get around that. They have to operate according to the law, but they also have to be politically cognizant, right? The ICC in particular has to recognize this. And so one of the things I would argue is that at this point, they really need to adopt what I would consider a transitional justice approach, right? So one of the things that's interesting about transitional justice, whether it's in South Africa or Chile or wherever, Hungary, wherever there's a transition from dictatorship to democracy, it's recognized as a moment when law operates differently, right? Usually we expect the law to be above politics, to be blind to the interests of individual parties. Transitional justice takes an approach that the law operates, but has to be aware of politics in the fragile nature of the legal intervention in a highly politicized environment. And the ICC needs to maybe learn that lesson and think about ways of doing that. And one of the ways I think it could do that is expand its use of the interests of justice framework, which has been very limited in its application and really could apply to a lot of different areas in terms of recognizing that for some states, maybe going after every criminal isn't viable because it's going to upset the domestic political balance and actually end up leading to worse outcomes. It could mean focusing resources a little differently, right? Like the ICC is stretched thin. There are lots of violations of human rights and humanitarian rights around the world. And so having a slightly higher standard than just everything that is brought to it might be helpful as well. But it's not just the ICC that needs to recognize this. The US needs to recognize this, right? Because the US needs to recognize that this is a political institution that the US can actually engage with, right? So in the short term, I'm hopeful that the Biden administration will really fully embrace the Dodd Amendment and use the tools it has to support investigations where it can, right? Because the US has been a key player in terms of turning people over to the ICC, helping secure those people who have been indicted. And in the long term, I personally think it would really behoove the US to engage the ICC in the reform process. The ICC over the past couple of years has been in a much more self-reflective mode. Partially, I think it might have been pushed somewhat by some of the pretty vociferous attacks from the Trump administration. But more generally, the member states have engaged in reform processes that have really looked at like what can the ICC do and do better with the resources it has. And the US should really engage in that because it could actually help to shape this institution in a way that works for US interests. And then lastly, I think the US really needs to consider what is the interplay with US policy here, right? The US maintains programs that impose sanctions on people, on states around the world. A lot of those states, a lot of those people are the same people that the ICC is concerned with. And so there's really some room for synergy there that could be explored. And that's just one example. Another is the democracy agenda that Biden has, right? He's having this democracy summit right now. What is the role of the ICC? If the US wants to reinforce international institutions that support democracy, this is probably a good one to support because this is one that a state like China is not joining anytime soon. There are other institutions where the US has to work against China. This is not going to be one of them. China is not going to join the ICC. So take those opportunities and run with them. All right. Thank you all. That's all for me. I hope to hear some of your questions and have a little bit of a discussion before you all log off and get some sleep. All right. Thank you very much.
Thank you, Chris. Can you see me or hear me?
I can, yes.
Oh, okay. I've never done this before, so
Awesome.
I'm just kind of a newbie in doing this.
No problem.
That was a great presentation, Chris. And although I used to be an attorney, I have to say I really don't know much about the ICC, and
Sure.
I think I've learned a lot here.
Awesome.
So we have several questions, and I want to try and find where I can get them. Oops, I don't know what I just did.
Okay. Click
Am
on
I
that
still
chat.
here? I'm trying to find my chat.
It's at the bottom in the middle.
Before I do that, let me ask a couple questions I have about the finances of the ICC. Where do they get their money? Has the United States contributed money directly to the court?
Yeah.
And you had also mentioned once about private donors.
So yeah, that's a good question. The ICC gets its money, like most international organizations, from the member states. The US does not give money, and it's actually prohibited from doing so under statute. So the Bush era statutes prohibited that, and those have stayed on the books. With regard to donors, one of the primary ways that donors would support the ICC is the ICC has a victims fund. So one of the things that ICC has tried to do is move beyond just prosecuting criminals to actually supporting the victims. And so the member states pony up a little bit, and then the ICC also accepts donations from foundations, et cetera, to provide assistance to the victims of like mass atrocities, war crimes, et cetera. Yeah, but the US is not really a participant. Where the US does provide money sort of tangentially is basically providing rewards to those who help find or get war criminals that might end up at the ICC, but it doesn't provide money directly to the ICC.
Okay, while my wife is on her computer bringing up the questions,
Awesome.
I have another question, and that does, can you talk a little bit about Spain's efforts to enforce international law, and does that have any relationship to the ICC?
Yeah, yeah, it's interesting. So the Spanish, I can't remember the name of the judge. So in the early 2000s, mid 2000s, Spain became a rather active, right, in trying to enforce international law with things like Pinochet era crimes. That was all separate from the ICC, and it was done primarily under universal jurisdiction, as opposed to some sort of statutory or some treaty-based right through the ICC. I think one of the reasons some states, actually some of the smaller states, like the ICC is because they see it as more even though it has political interests, obviously, they see it as maybe a little more even keeled than having to deal with their former colonial rulers. So like some of the pushback in the Southern Cone, I think, was really about, look, we will try these people, Spain, just stop.
Okay. Okay, here's, I have some questions now that I can see. Could you explain the difference between the International Criminal Court and the ICJ?
Sure. The ICJ is the International Court of Justice. That one is actually attached more formally to the United Nations. So basically, states become members of both, can become members of either institution, but the ICJ is basically a more traditional international court. Traditionally, international courts are all about state A versus state B. So the US v. Nicaragua, the UK versus Albania, right? And so basically then they take their claims to the court looks at international law and makes a ruling on for one or the other. The ICC is a much more recent invention. And although states become the members, the actual people that go before the court and are prosecuted are not states, they're individuals. So they follow that Nuremberg model of you, an individual military leader, you, an individual person who ran this camp, you individually violated the laws of war, or you individually created a situation that grossly violated people's human rights, and we're holding you personally responsible, and you personally will go to jail for that. So they sort of follow a different model.
Okay. Now, you mentioned the issue about the United States claiming that Palestine is not a sovereign state. What is the definition of a sovereign state?
Yeah. So in general, is basically an entity that like has a government that with territory and a population, and that's pretty much it under international law. The interesting thing is that Palestine, it seems to fit all the main definitional aspects. There's one fourth aspect that some people apply and others don't, which is more key here, and that's recognition by other states. So most people, I think, would say at this point you don't need recognition by other states to be a state, but it seems that that might be what Blinken is assuming. The United Nations, for example, has recognized Palestine as a non-member state, right, like an observer. So it's being referred to regularly throughout the world as a state. So it seems like it would meet the definition. Yeah, so it's interesting.
Okay, I want to add another question I have with regard to that. What about Taiwan? Is Taiwan a sovereign state?
No, and that is by mutual agreement of everyone, including the Taiwanese, right? So, so Taiwan and the PRC both claim to be the government of the whole shebang, right? So like Beijing government claims that it's that there's a sovereign state of China that includes the mainland and Taiwan, and the government's in Beijing, and the Taiwanese believe that there's a Chinese state consisting of Taiwan and the mainland, and the government's in Taipei. So,
okay.
One sovereign state.
Is the ICC on Biden's democracy summit agenda?
You know, that is a good question, and I don't think I know the answer to that. I don't think it is, but I actually don't have the agenda in front of me. What I've been hearing about is more things like democratic backsliding, corruption issues, things that are more focused on the internal workings of democracies. But I can't say for sure one way or the other.
Okay. One hears a lot about nationalism as a rising worldwide trend. Do you see this as a present risk for the ICC?
Yeah, I think it's an ongoing one. Yeah, I think that it's not just, I would say it's not just a threat for the ICC, it's a threat for all sorts of international institutions. Like even like one of the things I was saying is like within Europe, a lot of those states were willing to sign up to the ICC because they're just sort of used to this idea of transnational or international courts having some sort of say over what they do. And that is facing trouble even in Europe, right? With states like Poland pushing back against the authority of the European Court of Justice, let alone the ICC. So I don't think that this is something that is on the ICC's side. I think that there has been maybe a dialing down a bit with the change in the US administration, and less of like the Trump administration sort of provided a nice sort of central pole for others to sort of rally around, people like Bolsonaro, et cetera. And with that with that administration change, that's tamped down a little bit, but I think we'll have to see what time tells us about this. Okay,
and then the last question is, how many, and there's two parts to this, how many states now recognize the government of Afghanistan? And does this mean it no longer is a state?
I don't know how many recognize the government in Afghanistan, but it doesn't mean it's not a state. Right. So is in general, for international law purposes, you just have to have a functioning government and a territory and a people, and you can claim to be a state. And the need for others to recognize you is one that's been less and less supported over time, even though that is still some of the practice of governments around the world to extend recognition.
Okay, and the last questioner wrote another part to it. I see no ICC on Democracy Summit agenda with a question mark. And I think you've responded that you're not really sure.
Yeah, I don't think it's on there. I could be wrong. That one.
Okay. All right. Well, that's the last question I have. And Chris, I really want to thank you again for your presentation. I think we've all learned a lot, and we really appreciate it. And let me give an announcement about our next program, which is January 20th. Steve Niva, a professor at Evergreen State College, will discuss Israel and alternatives to the two-state paradigm. That's our program on January 20th. And thank everyone. I thank everyone for joining us. And thank you again, Chris.
Thank you very much for having me. Have a good evening.
Thanks. Bye-bye.